Mr. Govan and hang on one second, Mr. Wolf, you are here, and are we waiting for Mr. Delatoile? Oh, here he comes. There we go.
Well, Your Honors.
Very good. We have everyone in the courtroom, and just a quick question on the appellee side. Are you splitting your time?
Yes, Your Honor. Eric Delatoile here for Appellee Witburn LLC. We are going to split our time 10 minutes and 10 minutes.
And who's going to go first?
Your Honor, I will go first for Witburn LLC. I'll address standing, and then I'll allow Mr. Wolf to go second to address the remainder of the arguments.
Very good. So you'll each have 10 minutes. Excellent. Mr. Govan, you're up.
May it please the court, my name is Jan Govan. I'm representing Sammy Osman, who is the third-party purchaser in this matter. He has been specifically designated as a quasi-party by the lower court. This is a case in which we are contesting the jurisdiction of the court, and we find that the best definition of what happened really quickly is in the order itself, which says, this action began with plaintiff filing a complaint seeking this court to impose an equitable lien on the unrecorded interests in the subject property. The plaintiff in this case is Witburn. At the time of the filing its complaint, Witburn's complaint, there was a senior lien holder that had filed a lis pendens to foreclose the lien on the same subject property. Ultimately,
before you go further, do you want to reserve any time for rebuttal?
Oh, yes, please. 5 minutes at the end.
Very good.
Thank you very much. Ultimately, the court rendered a judgment imposing an equitable lien in favor of the plaintiff against the subject property. As ordered in the judgment.
Can I ask you a question?
Yes.
Because we all understand what happened here.
Okay.
We've all read this case and we know what happened here.
Yep.
And if you don't mind, I'd like to just get into the issue
I would.
before you spend time telling us things we already know, okay?
Okay.
So here's my question. Was your client in possession of this property?
My client was in possession of the property on the transfer of a certificate of sale post judgment. We're a third-party purchaser after the judgment.
And how was he in possession? I mean, just by virtue of the certificate of sale?
Yes, he was the winning bidder in the mortgage in the lien foreclosure case from the county court.
And that's the way that you claim that the county court has jurisdiction in view of section 48.23 subsection D?
No, our position is that the county court does not have jurisdiction.
Okay.
Because the statute, section 48.23, specifically bars enforcement of any claim of lien against the subject property.
But at the time you brought at the time you brought your suit, you were of the opinion that the county court had jurisdiction, and then after you learned of the senior lien, you basically took the position that it didn't, and you want your money back. Isn't that pretty much what happened?
We are identifying that the county court never had jurisdiction, that all of its actions are without authority to act from ab initio, from the very beginning. The action that the county court heard is barred from enforcement, and that's barred from enforcement. That language applies not only to the individuals, the holder of that lien, but under section 4 of 48.33, it applies. This section applies to all actions now or hereafter pending in any state or federal court in this state. So the county court did not have jurisdiction from day one. We only were able to participate in this matter after we were a purchaser. the foreclosure case in the senior lien case then took the property away from us. When we started looking at that reality, we saw that the senior lien case had exclusive jurisdiction, that the county court never had jurisdiction because this cause of action against that property, that same subject property, which is identified here in the order, that is the exclusive jurisdiction court. And any other court in this circumstance for an unrecorded lien that did not intervene in that senior lien case is barred from enforcement, and the court itself is barred from hearing it. That makes that a subject matter jurisdiction case because it defines a statute that defines a class of cases. That definition comes from this court from a December 29th, 2023 case, Tampa Port Authority versus Enriquez, which is number 2D23-1977, decided December 29th, 2023. And I filed that as a supplemental authority with that definition. Definition was subject matter jurisdiction refers to a court's constitutional or statutory authority to decide a class of cases.
And
therefore,
yes. What's the best case that gives you as a third party purchaser?
I'm having Judge, I'm sorry, but I'm having a hard time hearing you.
Okay, let me speak up. Can you hear me now?
I'm much better. Thank you.
What is the best case that gives your client the authority to challenge the subject matter jurisdiction in that Witburn Newport case?
It would be the Quadremain case, because Quadremain comes in and says the primary, the exclusive jurisdiction is in the senior case. The issue that we have is the judge in this case made an error when he said that a Jalali case, which is a second case that came in and said, we're going to change the facts. The facts are different because we're now dealing with a situation where we have a homeowners association or a condominium association, and we're saying that that bar to enforcement does not apply to a homeowners association because it is not an unrecorded interest. That homeowners association, in fact, does have a recorded interest in its declarations, which was filed even prior to the mortgage, so that the homeowner or a condominium who has declarations filed prior to the mortgage can come in subsequently in its own right and not participate within the senior lien mortgage foreclosure case.
Isn't that a distinguishing factor with Quadremain? Because here, Witburn did not have any interest. In fact, its interest wasn't created until there was an equitable lien imposed, right?
Well, that's exactly right. The point about it is,
but the interest in Quadremain was existing by virtue of recorded documents that gave an interest in imposing liens. May be inchoate, but it was an interest that's available. Whereas Witburn was totally after the foreclosure had occurred. Absolutely. Or it had been initiated. In fact, let me turn to another case that you cited, and I don't, if you still need to answer more of Judge Smith's question, certainly do that, but I have a question to follow up on.
I would ask Judge Smith if she needed further clarification.
No, I think I answered my question on what your authority was for that proposition. Thank you.
But our primary authority is the statute itself, which is a plain reading statute and defines specifically that a unrecorded interest subject to a senior lien mortgage foreclosure case has filed a lis pendens is barred from enforcement. And that applies to the court in terms of moving forward in its jurisdictional capacity, except that primary mortgage foreclosure case, which has exclusive jurisdiction over the interest in the property. Now, the issue.
And those are, you know, those cases are parties. Your client wasn't a party to any of those actions.
My client is a party. Once,
but not to the original actions, either the senior or the junior case. Your client comes in as a third-party purchaser, and, you know, it's the principle is that there's caveat emptor, buyer beware. You're supposed to have knowledge of what you bought, and it's an unfortunate circumstance because your client here did not do the due diligence that was required, because he would have had all of the knowledge of the record that there was this prior senior foreclosure case. And in fact, had your client looked at the actual record in the junior case, I think there was actually a notice that gave the case number.
Exactly. That is exactly right. And that requires these attorneys not to bring this case in the county court because they have a choice. They either had a choice to intervene within the 30 days of the original filing of the lis pendens, or
they're not seeking
they're barred from enforcement.
But they're not seeking any sort of priority over the senior lender.
They are barred from enforcement. They have no right to bring a cause of action that claims a lien against this property under the clear language of 4823-1D.
But Mr. Govan, the problem with that argument is it basically asks for an impossibility.
No,
it does, because you just said they had to bring any claim by intervening within 30 days, but they didn't have any interest at that point in time, correct?
Hold on.
No. Let's answer that first.
Yes, I'm going to, but I don't want to go next. I thought you were going to do another one. They don't have an interest in this property because they are barred from enforcement, but it doesn't mean that they don't have a remedy. Their remedy is to sue the property owner or the person they lent the money to for a cash judgment, a money judgment. But they have no right to proceed.
I understand that, Mr. Govan. I want to turn to one of the other cases that you cited as supplemental authority, which is the Ober versus Town of Lauderhill.
Yes.
That case does not stand for the proposition that there is no subject matter jurisdiction in a court. What that case does is say not enforceable.
Yes.
But it doesn't turn on subject matter jurisdiction.
The issue in this matter is the subject matter jurisdiction is a statutory prohibition that is a class of cases. The class of cases that cannot be heard by the court are those unrecorded liens that occur subject to the lis pendens. The court has no authority to hear that. And that is clear within the statute itself under 4, where it's
the statute doesn't say that a court has no authority to hear it. It says the court has no authority to enforce it. So as an example, if a claim was brought both for imposition of an equitable lien and also for some sort of constructive trust based on damages for breach of contract. I mean, I'm making it up as I go along here, but
okay,
the court would
I understand the question, but
the court would have jurisdiction to consider whatever the plaintiff presents, but the court may not be able to enforce the lien, certainly not against a prior lien holder. So I'm not quite sure how Ober helps you because it doesn't talk about subject matter jurisdiction.
Ober helps us because it shows that the courts, that any party who is bringing this claim of lien is barred from the enforcement. And Ober says, I can't hear it. Now, if we look at the language of the word
and in the Witburn lawsuit,
yes,
one of the parties could have said, Judge, you can't give them a lien on this property if you interpret the statute the way Mr. Govan is now arguing. And that might have been a good defense, which of course did not happen. So the question now becomes a third-party purchaser who has very limited rights in challenging an underlying judgment, you're saying, well, not only do I want to challenge the underlying judgment, but I want to say the court had no authority to do anything.
That's right. That's absolutely
I just
right.
want to make sure I wasn't misunderstanding your argument. And just to let you know, you've got 5.5 minutes left. So in 30 seconds, you'll be invading your rebuttal time.
All right. In the case of Lawrence versus Marina Towers, Lawrence next argues that the trial court abused its discretion because Gibraltar was a non-party to the foreclosure proceedings. While not a party in the first instance, Gibraltar, as a third-party purchaser at the foreclosure sale, is a quasi-party with standing and does not need to formally intervene. I can't intervene in this case because the judgment's already issued. But as a quasi-party, I have standing to bring forward my claims, and any person has a right to challenge the jurisdictional responsibility or authority of the court. In this case, the court cannot hear this matter as a result of a statutory responsibility under 48.23, because the matter under a barring is destroyed, is to defeat and destroy the action altogether. And there can be no enforcement because enforcement only relies on is predicated upon a valid judicial decision. There can be no judicial decision for a cause of action which is barred and destroyed. So the court has no jurisdiction to even hear the case because the case doesn't exist. It's barred, it's destroyed. They can't come forward under any circumstance to bring a cause of action in this way as a result of the prior matter, which the court has recognized, which these attorneys who brought this action knew of, participated in, and violated the terms of that statute. I'll defer to my opponents.
Very good. You'll have 3.5 minutes for rebuttal. Mr. Delatoile, you're up.
Yes, thank you, Your Honors. May it please the court, Eric Delatoile here on behalf of Appellee Witburn LLC. Mr. Wolf and I are going to split our time. As I mentioned, I would like to focus my time on whether or not the appellant has standing to come here before this court and ask it to vacate a judgment. I'll defer to Mr. Wolf on the jurisdictional 48.23 arguments. I think as stated, the appellant is a third party who purchased the property at a foreclosure sale. They are not a party to the case. They have not sought intervention to be a party to the case. They are solely deriving their claim as a quasi-party. They cite 3 cases, Your Honor, in their reply brief that they believe gives them the authority and the standing to try and vacate a judgment that they were not a party to. The Lawrence v. Marina Tower case is not a case in which the third party vacates the judgment. They were brought in as a quasi-party solely to handle a post-judgment and post-sale sanctions issue. At no time was that third party attempting to vacate a judgment. Along with the Lawrence v. Marina Tower case, in its progeny, there are 2 other cases that counsel for the appellant cites. That's the Stratton v. 6000 Indian Creek case and the Miller v. Stavros case. Again, neither of those cases are ones in which the third party gets standing to vacate a judgment. In Stratton v. 6000 Indian Creek, the third party was seeking the ability to get a writ of possession. The court said, yes, you can get a writ of possession even though you're not a party to the case. In Miller v. Stavros, they were attempting the third party to get a surplus disbursement. Again, not attacking the judgment. They realized that their claim is only post-sale claims. Counsel cites no cases that allow a third party to come in and attack a judgment for which they were not a party. We actually do cite a case that we think is directly on point. The Thriving Investments v. Chow case, which is from the 3rd DCA, is the exact same scenario we find ourselves in here today. A third party purchases the foreclosure at a foreclosure sale. They believed they were purchasing a first lien when in fact they purchased a second lien, and they sought to vacate the judgment. The court in that case said you are a stranger to the litigation. You have no standing to vacate the final judgment. And in fact, went on to say the appeal is dismissed because the general rule is that a non-party is a stranger to the record who cannot transfer jurisdiction to the appellate court. That's exactly what the appellant is trying to do here. They are trying to derive this quasi-party standing to attack a judgment when they were a stranger to that litigation. All cases they have cited only involve post-judgment, post-sale requirements. I don't believe that they have standing to come here
So
before
what's
Your
their
Honor.
remedy? What is their remedy?
Well, if they
They
wanted
don't
to
have
try and
standing here. Yeah. What's their
if they
remedy?
wanted to try and vacate a sale, there is a standard that the court has already set when it comes to vacating a sale. That would be something that they may have standing to do. They haven't sought to do that because I don't think they meet the requirements to do it. They would have to try and show some kind of gross inadequacy or mistake or fraud in the actual bidding of the sale itself. There was no evidence presented that they could do that, and I think that's why they didn't try to attack the sale.
So is your position they just brought all this on themselves and they're just stuck with it?
Yes, they had a duty and an obligation. I think there is a plethora of case law that when you purchase a property at foreclosure sale, it is caveat emptor. It is buyer beware. You have a legal obligation to do research to see what you're buying. In fact, that's why I filed that notice of a senior lien case in it so that a party does not get mistaken and think they're purchasing a first lien when they're purchasing a second lien. Here, unfortunately, that's what occurred, and I think that is why they're trying to say they have standing as this quasi-party. I don't believe they have standing to do that. With that said, I will defer the rest of my time to Mr. Wolf. I believe he will talk more about the statutory arguments that have been raised.
I may please court Matthew Wolf on behalf of Newport Properties. First, I want to discuss the Quatermain and Jalali distinction. Mr. Gavon raised Quatermain in the trial court. He didn't raise it in his initial brief. He raised it in his reply brief, and then he filed the Ober case last night. There's a large distinction between Quatermain and Jalali, which is what the trial court relied on was Jalali. In Quatermain, there was a junior interest, which was attempting to foreclose the senior mortgage holder out. That's what took place in that case, and that's why the court came and said, you don't have the ability to do that under 48.23. You would have had to intervene within 30 days and assert your interest. Jalali is different. Jalali is a situation where there's a junior interest foreclosing out the homeowner that doesn't affect the senior lien interest. And the Ober case that he's filed last night and cited is merely a repackaging of the Quatermain matter. The Ober case is a situation where first lien forecloses after the sale, but before title, or after the judgment gets entered, before title issued. The city records a bunch of code enforcement liens. It goes to auction at the first mortgage foreclosure. That gets sold back to the bank. The bank sells it to Ober and wants a quiet title and take all these liens off the property. And initially in the trial court, the city's liens remained, and it was overturned on appeal. If it wasn't overturned, what would have happened is a junior lien interest would have taken priority over the mortgage. All it is Quatermain repackaged in a different format of a junior lien attempting to foreclose on a senior lien's interest. That's not what you have here. You have Jalali, the junior lien or junior interest foreclosing on the home. And I think that's the purpose of the list pendant statute. It was cited in the Jalali case. The purpose of the list pendant statute is to, one, protect third-party purchasers from being engulfed in litigation, but two, to protect the plaintiff in the case, to put everybody on notice that we have a pending action, and if you do anything with this property, it's going to be subject to my lawsuit. Nothing in 48.23 discusses jurisdiction. Now, I agree that if anybody wants to assert an interest against a senior lien, they have to do so within 30 days of that list pendants being filed, which would only make sense because if you're a first mortgage holder and you want to foreclose your interest, you record your list pendants, you run a title search, you want to name everybody who has interest in the property. If there's anybody out there that doesn't have interest, you don't know, it's not going to show on your title search, so you give them time to intervene. But they don't have the entire case in years to assert their right. Okay, they get 30 days. You step forward, you assert your interest in 30 days, or that party gets to proceed forward without you. I think that's what 48.23 stands for. It doesn't stand for anything related to junior interest of the list pendants which acquire at a later point in time against the homeowner. That would be Jalali, and that's why I think the court properly relied upon Jalali in making its decision. Judge Smith, you talked about earlier, caveat emptor. Buyer beware. This case, if you go through the case before the case record, in the stipulation, the party stipulated that this was junior. In the judgment itself, in big bold print, even above, right below the case file, above where it says final judgment, it says this is junior to other liens that are outstanding. And then what counsel for the plaintiff in the case filed his notice of senior lien case. Caveat emptor, the buyer was on notice. There was a first mortgage on this case. All he had to do was look at the judgment, and he would find this out. And not in addition to the other cases out there that said he's on constructive notice because the mortgage was recorded. This is a situation of buyer's remorse. He went out, he didn't do his due diligence, he bought the property, he didn't like it, and now he's just trying to set this aside in any way that he possibly can do so. Which is why we've got the Quest case also cited in the trial court's order. If you read the transcript, Mr. Osman took the stand. Mr. Osman testified. He didn't hire title counsel. He didn't hire title report. All he did was his own due diligence. He didn't look at the court records. He didn't look for a list pendants. The Quest case, and which Quest also cites to Canfin, says, look, you got to protect your own interest here. If you're going to go buy something at auction, you need to protect your own interest. If everything is of record, then sorry, that's what you get, caveat emptor. But in the Quest case went a little bit further, says, look, there was an issue here and you weren't able to discover all this because it was done by the parties to cover it up. Like, you can connect those dots, and then if you want to make those claims, you can. But that's not what they're doing here. They're just saying they're trying to find any way out of this purchase. And I think the court it was appropriate to enter the judgment based upon Jalali because of the junior lien interest. I think it was appropriate to read the statute the way that it did, that it doesn't apply to interest which accrue at a later point in time against the homeowner and not the first lien holder. I don't think quasi-party can carry the day here because nobody was foreclosing the senior interest. I don't think Ober creates a distinction there because, again, this was a junior interest. The court doesn't have any questions. That's all I have.
Very good. Thank you very much.
Thank you.
Mr. Govan, you've got your 3.5 minutes.
Thank you, Your Honor. Statute's clear. The recording of such lis pendens in the senior case constitutes a bar to enforcement against the property described in the notice of all interests and liens. You can't come in underneath that because you are barred from enforcement. These lawyers decided to skip over that and go into a county court, and they then acted to enforce a lien that was barred because of the senior lis pendens. They even admit that they know it. They even admit they filed notices to it. They even admit in the judgment that it's a junior lien filed subject to and subordinate to the senior lien case. So how can they even think that this court has jurisdiction to do that when they are barred and the court is barred? That language barred means no. And that's speaking to these plaintiffs and this plaintiff and appellees, and speaking to the court itself. And if we have a doubt that it's speaking to the court, then we need to simply look at 4 that says this applies to all cases in state and federal courts in this
Mr.
state.
Govan, if we were to agree with you, would we then need to conflict with Jalali?
No, Jalali is a case relating to a homeowners association. It is not an unrecorded lien. Jalali is in fact recorded in its declaration of homestead, which precedes the mortgage itself. It also applies to condominium associations. They're recorded liens from their declaration.
They did not intervene, did they, in the existing lawsuit?
In Jalali?
Yes.
No, they did not, because they didn't
have
to, because they had a superior lien.
Was it superior? Or I thought it was junior. Am I misremembering Jalali?
It is solely based, Jalali can proceed solely based on a prior recorded interest in the declaration of homeowners association. Then a subsequent matter occurred where they didn't have a payment. So they brought an individual action based on their prior recorded interest. In this case, there is no prior recorded interest. They did not have a lien
until later.
They didn't have a lien until later, but they had
a recorded interest. They could not foreclose. They could not foreclose against the first.
They did not foreclose against the first.
So
they didn't bring an action against the first. It seems to me
that we would potentially be in conflict with that portion of Jalali that basically allowed a court to exercise jurisdiction on what is now a junior lien.
Except this is an unrecorded interest that has no claim to being recorded in any way prior to or at any time except subject to. So you can't just come in and say, oh, by the way, we secretly have something, and what we're going to do is come in afterwards and try to enforce it, and underneath that, when it's clear that you can't do that. The reason Jalali goes forward,
Mr. Gavan, you're at the end of your time. You've got about 10 seconds to conclude.
The reason Jalali goes forward is clearly because they have a declaration filed prior to, and it relates back to that declaration of homeowners association. In this case, there's no such prior relation to that.
Very good. Thank you all for the presentation. You may leave the courtroom by hitting your exit or leave button. You're welcome to watch more oral arguments if you so choose on YouTube. Thank you very much.
Thank you.
The next case on the docket